email are popular ways that law firms communicate with their clients and opposing parties, as well as advertise their legal services. We're here today to talk about how lawyers can properly disclaim their communications to ensure that they comply with the rules of professional conduct. I'm Christy Lewis Abate, Vice President of Underwriting.
And I'm Chris Stigemeyer, Director of Risk Management for the Barclay Mutual Insurance Company. And today's topic, as you mentioned, thank you, is disclaimers. One, there's a very popular myth in Missouri that a disclaimer is required for Missouri attorneys on their emails. And that is completely false. There's no such requirement to have a disclaimer on emails. What lawyers are required to do is to consult with their client about the means that they're going to utilize to communicate with the client and the client communicate with the attorney. This cannot be done in a boilerplate disclaimer that it shows up on every email. So the what I always see as the potential harm in this, every lawyer needs to have a disclaimer on their emails, kind of an approach, is that it blinds lawyers to their actual duty, which is to consult with the client about the means of their communication, not to simply have some silly boilerplate language that shows up on every email. This was brought home to me when I was looking at a lawyer's website. I don't surf websites or anything like that. I was trying to find out information about the attorney so I could contact them. And I was looking at the website, and they actually had a disclaimer on their website which said, and I copied it, the Missouri Bar Disciplinary Council requires that all Missouri lawyers inform all email recipients that email communication is not a secure method of communication. And then it goes into all of the silliness that you often find in the email disclaimers themselves. But this was actually on the website, and it was on the Contact Us page. Well, this is just a mishmash of all kinds of improper understanding or misunderstanding of the lawyer's duties. First, regarding the email disclaimer and the communication that, or the consultation has to occur with a client on that. And then also what lawyers need to do to protect themselves when they utilize a Contact Us page on their website. The problem is that that is a solicitation. That is, when a lawyer asks or makes available or makes it apparent to the visitor to the website that they can communicate with the law firm, that is a solicitation by the law firm. And when somebody responds to that, that solicitation then can potentially morph into a consultation. And once you get into a consultation, then all kinds of hilarity can ensue because duties can start to run to that individual through the information supplied on the law firm's website. So, what I recommend that lawyers do is to carefully review comment 2 to Rule 4 1.18, which is duties to prospective client. And once again, I have a copy here of that comment. A person becomes a prospective client by consulting with a lawyer about the possibility of forming a client-lawyer relationship with respect to a matter. Whether communications, including written, oral, or electronic communications, constitute a consultation depends on the circumstances. For example, and oh my goodness, they give an example right here in the comment. This is really valuable stuff, everyone. For example, a consultation is likely to have occurred if a lawyer, either in person or through the lawyer's advertising in any medium, specifically requests or invites the submission of information about a potential representation without clear and reasonably understandable warnings and cautionary statements that limit the lawyer's obligations, and a person provides information in response. The important thing to understand is, what does the lawyer, what do you, for example, on your website want to warn about and give a cautionary statement about? And I see all kinds of really worthless language. Don't provide any language that's confidential, blah, blah. Well, lawyers don't even know what confidential information is. And now they're going to offload the duty of understanding that to somebody who's visiting them on their website. In other words, the standard kinds of warnings and cautionary statements just don't do their job on that. And a much better approach, quite honestly, is to provide a very specific form that limits the information that a visitor to the website can provide. That's the best thing to do, not to just give this open ended sort of dialogue box where somebody can drop anything in that they want and then send it to the law firm. And then finally, because the website invariably is advertising, it requires the advertising disclaimer to be conspicuously placed on the website with language from the rule 4-7.2 that states the choice of a lawyer is an important decision and should not be based solely upon advertisements. And that is something that I often see does not happen on law firm websites. It's either not conspicuous or it's not there at all. So the use of disclaimers by lawyers in these settings, in some time, in some circumstances, is required. In some circumstances, it can be helpful, but it's very important that lawyers educate themselves on this topic so that they can protect themselves appropriately in these circumstances from improper communication usage at all or unintended attorney client relationships and duties that can flow from that.
Thank you for that information, Chris. I'm Christy Lewis Abate,
I'm Chris Stigemeyer.
and this is your Risk Management Minute.